and it's better to have the official information. And I think we've talked about it, we've heard about it, we talked about it in our breakout session, getting together with the judge and with the court staff to try to determine a way to lay ground rules that everyone can live with, at least for the most part, in advance of the trial or the proceedings, is key. That happened to a certain, to a certain degree in the Michael Jackson case. And we had a pool coordinator, Peter Shapin, who you'll hear from tomorrow. The journalists banded together, dealt with Daryl Parker and the court staff, and I think the one thing that was missing is we never really did sit down with the judge ahead of time, and map out some rules on what should be, what shouldn't be sealed, how the lawyers should be able to communicate at least background information about the case, rather than hearing from the pundits who don't know what's really happening. And I think there were middle ground places that would have served the purpose, and that communication would be helpful. I represented the news organizations way back in the Clinton era, during the Ken Starr's investigation of the Monica Lewinsky events. And there were big hearings on executive privilege and the Secret Service privilege issue, and they were being held in secret, and we had filed an appeal, and I argued the appeal, and then I got back to my office, and Chief Judge Norma Holloway Johnson had left me a message at my office saying, I want you to come to the court for a meeting tomorrow. And I thought, oh, this is great, because we were attacking her orders. But it turned out she had decided that it would be better to get the lawyers together with all the judges and try to map out some rules going forward. And that deflated a lot of the tensions and the pressures, and then we had subsequent meetings. She ultimately held some of the executive privilege and Secret Service privilege hearings in the open, even though they were ancillary to the grand jury, and it made a huge difference, and everyone just got along better. And again, we weren't totally satisfied, but it was a major break in terms of public access to the case. The other thing, I think, and I'm looking at this more from the journalist and the media lawyer standpoint, is the phrase "feed the beast" in some way. And if you can't feed the beast, make the beasts comfortable with good facilities and fast information. If the court feels that it can only give out so much information, do it in a contemporaneous way, because it really goes to the core of what the reporters are doing. That's reporting on what's happening in the court, in the trial, at that very moment. And the delay, even if it's a delay on something, the courts or the lawyers might think, why would anyone care about that? The journalists are trying to really understand what's happening. So they need to know from the mundane to the important. They need to know it contemporaneous with the events that are occurring in order to do their job. So I think thinking ahead, and I think this has improved definitely in the last decade, in part because of Jerry Ann and others who have thought about these issues, but I think that kind of communication, laying the groundwork and cooperating, could go a long way towards improving things for everyone.